Now call 124-992 State of Kansas versus John Pepper.
Good morning, almost, barely. May it please the court, Laura Stratton appearing for the appellant, Mr. John Pepper. I request 3 minutes of rebuttal. We have 3 claims in our brief. Of course, we do not waive any of them, but I would like to address the first 2. The first is the lack of sufficient evidence used to convict Mr. Pepper. And the second is an error of law that excluded expert testimony offered to show that Mr. Pepper lacked the propensity to commit the crime. The crucial thing to understand in this case is that there's only one material fact in dispute, to borrow a phrase from the civil law. The facts of this case are almost entirely undisputed. The only issue is whether RG consented to sex with Mr. Pepper. If she did consent, then her heart attack during sex was an unfortunate medical event, but there is no crime. If she did not consent, then Mr. Pepper is guilty not only of aggravated criminal sodomy, but felony murder, because again, she had a heart attack. There is no dispute that they had sex. There is no dispute that she died of a heart attack. There is no dispute that her body experienced quite a number of injuries as a result of very violent resuscitative efforts that went on. So paramedics were called, they performed CPR, they broke some ribs, they dragged her body from one room to another to get more access to her. And they shoved a breathing tube down her throat. So there were
Actually, counselor, didn't they say that there clearly were bruises over the course of RG's body?
Yes,
And some of those bruises could have been caused by resuscitative measures,
yes,
but they could also have been caused by choking or hitting or other harm that was inflicted on her by someone else.
what the coroner testified to is that the bruises could be consistent with non-consensual sex, but they could be consistent with many other things. For example, falling forward, or another set of bruises was consistent with falling backwards. So I think that the point of the medical testimony is that there were so many injuries and they were so nondescript that they were a little bit consistent with everything. And that consensual sex could not be ruled out by any of the medical testimony.
But weren't you asking us to look at the evidence, making inferences in a light most favorable to the defense?
No, I am not, because I am actually, I encourage the court to look at the appellee's brief, because the court does not need to take my word for it. If we go to page 9 of the appellee's brief, the state gives this court the best it has. It says, the first full paragraph, the top, when the evidence is properly viewed in the light most favorable to the state, it shows that. The end of that paragraph, Peck, who was their sexual assault nurse examiner, explained that the injuries of this paragraph could be consistent with consensual sex. The next full paragraph at the bottom, this is the coroner. This is the main medical witness. She explained that while some of the victim's injuries, specifically broken ribs, were likely caused by resuscitative efforts, other injuries, such as those to the victim's mouth, which included the bruises, were not likely to have been caused by efforts to resuscitate the victim. So what that tells us is that there are some injuries that the state couldn't explain and that they were consistent with consensual sex. The best they have is consistency. And that means that at no point has the state ruled out the reasonable doubt that it was also due to consensual sex. And that is the bulk of the state's medical testimony.
But in addition to the medical testimony, you did have other testimony from people that not to have engaged in any relationship for 20 years, and she didn't tell her best friend about it. And does that go to consent also?
Sorry, one moment. Could go to consent, yes, if that had been the testimony. So, pardon me. Celibacy is the state's word that it used several times. It asked witnesses about whether or not RG was celibate. They said yes. The thing about celibacy is that when someone is celibate, they doesn't tell us anything about whether they are celibate because they choose to or because they lack the opportunity. And the state didn't really want any witness to go past that initial question of whether she was celibate, but one witness did. And one witness told us, actually, RG did desire sexual expression. She did have a man at one point. We don't know when, the witness didn't remember. It could have been a year ago, it could have been 20 years ago, but she did have a boyfriend. But he wouldn't stick around because her daughter and her grandson, who were in trouble with drugs and the law, were too much trouble. So she couldn't keep a man around. What that tells me is that she did desire sexual expression. And though she may have been celibate, it wasn't necessarily because she chose that.
But that could also, the jury could infer from that, that when she was engaging in sexual relationships, she would tell her friend.
They certainly could. That is true. Yes, they could make that inference. But they didn't. I mean, so they didn't.
Sounds like they kind of did.
Well, they didn't say that RG told them either way. They said, we never saw her with a man. So I think
No,
that's
I'm talking about the jury drawing an inference.
right. So the jury, but the jury can't ignore evidence. And this court standard, even though we do have to look at the light in the facts in the light most favorable to the state, we can't ignore evidence. And the evidence did show that she did desire sexual expression when given the opportunity. So the jury wasn't entitled to ignore that. It may not have given it weight, and we have to, when we're dealing with sufficiency of the evidence, we have to let that go. But
So, I mean, because your argument is sufficiency of the evidence,
that's,
right?
yes. But in a case where the medical testimony is literally non-probative, because it doesn't tell us one way or another whether she consented, and consent is the only question here. So where there is no probative medical evidence, the fact that, let's say RG even did tell her friends, I'm not interested in sexual expression. Is that enough? Does that reach beyond a reasonable doubt? I submit that it does not. And that what it really does is.
That's the jury's province. We don't.
Well,
Yeah, I mean, you're just talking about, is there sufficient evidence from which a jury could conclude beyond a reasonable doubt that, on the medical evidence that, that there, even though there was conflicting evidence, right? That there was evidence that it was non-consensual, physical evidence to prove that. Plus you have, the jury weighing all these other people coming in.
yes, and I submit that I don't think the medical evidence is conflicting. I think it's non-probative. And that, no, I do not think a rational fact finder could, just based on a friend saying, this is what she told me, say that then Mr. Pepper must have forcibly sodomized her. But even if this court does find that there's sufficient evidence, and I understand that's a very high bar, there is a second error of law. And that error of law is that the trial court excluded an expert opinion showing that Mr. Pepper had no indication or history of sexual deviancy. So there are three issues with this ruling. The first is that it's internally incoherent. So that the court gave two reasons for this ruling. The first is that this expert testimony stating that Mr. Pepper was not sexually deviant invaded the province of the jury.
What does that mean? What are we to infer that means? From the proffer, that was the only thing that that counsel told the court they wanted to present, was that there was some evidence from a psychologist that Pepper did not suffer from a sexual deviancy. What does that mean?
So respectfully, that is not at all that the defense proffered.
Tell
This-
me all
Mhm.
that, give me your strongest argument of
Yes.
what the proffer was.
Defense gave the state a 15-page report pre-trial by Dr. Parker.
Is that in the record?
The actual report is not, but citations to the specific sexual deviancy test is in a pre-sentencing motion by the defense. So there was an expert report. The
But
state,
was it presented to the court as part of the proffer?
it was in a pretrial hearing. So there was a motion to eliminate, the state filed, the defense replied, and then there was a pretrial hearing on the issue of Dr. Parker's testimony.
But the pretrial hearing is not part of the record, right?
The pretrial hearing is, the expert report is not.
Okay, so we don't know what the diagnosis was.
We know from the citations in the pre-sentencing motion that he was diagnosed, he had taken a test, the name of which I forget, And the court found five things that it could, I'm sorry, the expert found five things that it could find to say about Mr. Pepper, which were that he was not sexually deviant, that he did not need like abnormal sexual, he got pleasure from normal sexual desire. I'm sorry, let me find the exact thing the court said, he was not likely to engage in extreme or aberrant sexual behavior. His sexual interest in no way interfered with normal functioning. His view on sexuality was conventional. He received pleasure without needing to engage in high risk or unrestrained sexual activity, and he did not display any sexual deviancies. That was in the pre-sentencing motion.
A proffer is an evidentiary issue concerning evidence that is excluded from the trial. And proffers can be, do you agree that proffers can be presented either by oral argument from the attorney, if the court agrees to that, or a question and answer session that is done as at a break from the trial outside the the presence of the jury?
I do.
So what was included in the evidentiary proffer that we can consider as part of the proffer?
I think the court can consider this pre-sentencing motion because the case, I believe it's Swint, which is cited by the state, says that the court can even consider or has in the past considered proffers given after the trial. And that's in the case they cited. So they certainly could consider the pre-sentencing motion.
Counsel, have you thought about the consequences of what you're asking us? Because if you're saying that the assessment of your client's relevant to whether or not he, and I do have some issue with sexual deviancy versus forcible sodomy. But what if it would have, what if you were on the other side and the state was trying to introduce evidence that your client was sexually deviancy in an attempt to prove
I would point out to the state that the legislature, when it created KSA 6447, doesn't treat the defense and the state the same. That 6447B specifically gives the accused in a criminal case, when it wants to offer an opinion, including an expert opinion, in its defense, that it can do that. And the state does not have that same right. So I guess I would respond that that's exactly what the legislature intended.
And that's exactly the purpose that the defense attempted to introduce this evidence was to establish a character or a trait that showed a lack of propensity to commit at least sexual deviant crimes in general. And that sort of character evidence under 6447 or that series of statutes. Is that a fair summary of
That is almost exactly what 6447B states. Is that
and then
right?
does the state get to come in and have its own expert to rebut that?
It gets to bring in specific instances of conduct. So Mr. Pepper wanted to open the door. And I submit that if the state had specific instances of conduct to bring up, it would have done so. I don't
So
think
the state
it
doesn't have the right to also have him assessed by an independent person.
without Mr. Pepper opening the door.
No, I'm saying, Mr. Pepper opens the door and says, I've got an expert that gave me this battery of tests, and here's what the expert says. And then does the state get to come up and say, I'm going to call a rebuttal expert now that I've seen your expert report, and I'm going to have my rebuttal expert assess the client, and we're going to have dueling experts.
If my reading and memory of 6447A is correct, A allows them to bring in specific instances of conduct. I cannot, as I stand here, think of a reason why that couldn't come from an expert witness. So I guess my answer would be, I don't see why not. But that I haven't been focusing on 6447A because again, the statute specifically treats what the state can do and the defense can do differently for a reason.
Do you agree that instances of rape have been done by people with or without sexual deviancy?
Yes.
And so uh, if the court determined, which it did below, that this simply is more, there's more of a chance for prejudicial value. Unfair prejudice outweighs any probative value, which essentially would be to bolster the defendant's credibility. What's your position concerning that ruling by the court?
My position is that, and I don't have the case law on hand, but in researching this issue, I found case law stating that 6447, when it talks about characters and traits, is kind of specifically excluding credibility, that those are different evidentiary rules if the evidence is offered to bolster or negate credibility. But I think maybe you're also asking is what would be the standard of review? And that would be abuse of discretion.
Well, it's two parts. I mean, there's a lot of case law that indicates that character evidence like this does have the purpose of simply bolstering credibility, and that's why it is not probative. Would you agree?
Yes, I think so, yeah.
And so here, the court used a 445 standard of stating that I'm still not going to let this evidence in because any probative value is outweighed by the risk of unfair prejudice to the state. So what's your strongest argument that the judge ruled in error?
Actually honest, I would have to admit that my opinion on that is that the judge did not actually invoke 445, because 445 weighs probative value versus the risk of surprise.
But hasn't that consistently been interpreted by this court as undue prejudice, not just surprise?
Fair.
And even recently in 2023, a Court of Appeals opinion held that.
Fair. And so absolutely. And the ultimate answer is that, of course, 447B excludes the judge from using 445 to disallow the exact evidence allowed in by 447B. Cannot be used in that case.
When it's being offered by a defendant in a criminal proceeding to prove innocence.
Correct. Yeah.
Right. And the other cases where we've historically found that expert character opinion evidence to be inadmissible has typically been when the state introduces an expert report that essentially vouches for the victim's account of or testimony concerning the event. Or are you aware of any case law where it's been applied beyond that sort of limited context?
I hope this answers your question. I could not find much, if any, case law in which it was used to disallow a defendant trying to explain a character or a trait. Because you're right, I think it's usually the state who wants to bring it in. So there's not a lot of case law on the other side.
I have one quick question, if I could. Back on sufficiency of the evidence. Your client testified at trial, and the jury obviously did not believe his story.
Correct.
My question is a defendant's testimony that is simply unbelievable, that circumstantial evidence that a jury can consider when determining whether the state met its burden?
I take your point, and I didn't research this, so I don't know any case law, but again, I can't think of a reason why disbelieving any witness couldn't be used in that way. But I guess just from a first principles,
Sorry to interrupt, but it kind of seems like a jury can use that as circumstantial evidence.
right, and I don't want to concede it because I haven't researched that specific
Sure.
issue, but I absolutely take your point. And I guess my point is just that even if that is the case, the idea that just a defendant lying means he committed forcible sodomy and felony murder, that reaches beyond a reasonable doubt is very difficult for me to accept. Questions? Thank you very much.
Maloney?
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. With respect to issue one, the sufficiency of the evidence, the arguments that I've heard advanced today by counsel and also in the brief are arguments that are certainly well placed before a jury. Essentially, she's pointing to what she considers to be conflicts of the evidence. And I think in the defense brief, they actually use the word ambiguous in describing the evidence. So while it would certainly be fair to get up in front of a jury and say, hey, the state hasn't met its reasonable doubt standard here, we're not at the reasonable doubt phase anymore. We're at the appellate phase where this court ignores evidence in the defendant's favor and looks at the evidence in the light most favorable to the state. You don't reweigh credibility. You don't look for evidence that would conflict with the verdict. Counsel paraphrased my brief as far as what I pointed to or what she characterized as my best evidence, because I used the phrase when looking at the evidence in the light most favorable to the state. Respectfully, my entire argument in that issue was based on light most favorable to the state, not just the one or two paragraphs that she cites. But within those paragraphs, I would note that the coroner did testify that while there were a lot of injuries to the victim's body, and while it was not possible to determine specifically with respect to all the injuries whether they were caused by the resuscitative efforts, she did specifically say that there were several injuries or some injuries that were not consistent with that. And so I think, again, when you keep in mind the proper standard of review, we presented plenty of physical evidence to support the verdict in the light most favorable to the state. And then, of course, we did have, setting aside the physical evidence with respect to the injuries to her body, we have all of the circumstantial evidence. I cited in the brief fully the list of health problems that the victim had, and I won't recite all of those in oral argument, but suffice it to say, she had a lot of health issues. We did have this testimony from multiple people who knew her extremely well, saying that she had not had a boyfriend for 2 decades, that they did believe that she was celibate. They had never even heard her mention this man in any possible way that would lead you to believe that she was having a relationship with him. We also have the evidence that she was so eager to get him off of her property that she wasn't even allowing him in the home and was essentially forcing him to stay in the yard. But she had even told her daughter that she didn't even want him to do that anymore, that she wanted him removed completely from their home. And then, of course, I think touching on Justice Stiegel's questions, you do have the theory of defense in this case, which is that this 72-year-old woman with a litany of health issues who had had no history of sexual contact in 20 years would willingly agree to engage in anal sex with a homeless man who hadn't showered in 4 days and was essentially squatting in her backyard, that she would do that because he suggested it might help with her constipation. I think when you look at all of the evidence, both physical and circumstantial, it was more than sufficient, especially when you're talking about the appellate stage, for the defendant's high burden to show that there was not sufficient evidence to support the conviction. Turning to issue 2, certainly I'm happy always to answer any question that this court has, but I will start by saying that I will probably not be very helpful with respect to KSA 6447. And I reviewed the brief as I was sitting at counsel table just to make sure that I hadn't overlooked it. But that statute was not cited anywhere in the defense brief. It was simply not relied on by the defense in the appeal. And so to the extent that I am not able to articulately answer any questions about that, I apologize in advance. But when you look at the record here in this case, you see that the defense, when they tried to advocate for this testimony at trial, and the state objected and said that it wasn't relevant. And essentially, the defense attorney's response was something along the lines of, and I'll cite it here. I can find the correct Yeah, when asked the defense position, defense counsel said, I understand the state's position. The only thing I would add on our side of the situation is I think it's relevant. We aren't talking about any type of scientific behavior or if the defendant has more proclivity to try to rape somebody or not try to rape somebody. And then he goes on to basically summarize that Dr. Parker found that he doesn't suffer from any type of deviancy. And that's essentially the extent of it. Those two brief paragraphs. So
What
our-
about what was appended to the motion, the sentencing motion? Can that be counted as a proffer?
I struggle logically to understand how something that occurs after trial and before sentencing could be considered when the district court obviously was not in position to consider it at the time that it was being asked to rule on the admissibility of the evidence. I don't even know from a practical standpoint how that would play out. Would you just go back after the trial and before sentencing when the defendant makes this proffer and then the court thinks, well, I guess based on that, we should have allowed it. So we're just going to go ahead and have an entirely new trial. So I don't really understand how something, I think it's much the same as a contemporaneous objection when somebody's trying to exclude evidence. If 20 pages later or 5 witnesses later, if an attorney thinks of a different argument, that's not a contemporaneous objection. You have to give the judge the opportunity at the relevant time to consider the argument that you're advancing as far as why something is or is not admissible. And so here, when something is offered as a pre-sentencing exhibit, I don't logically see how that could be factored in. And as far as the exhibit, counsel's acknowledged that that's not included in the record. And obviously, it's always the appellant's burden to show that a district court committed reversible error. And this court cannot make that assessment based on an exhibit that none of us have seen. More generally, I would just note that, yes, we know that this witness was a psychologist. We don't know, because of the insufficient proffer, we don't know whether he has any specialized training in detecting or testing somebody for sexual deviancies. We don't know what specific tests that he might have put him through, what the, whether these are peer reviewed. I have no idea. It's very difficult to say. There are things in the record, I think, with respect to certain testing that he performed on the defendant. But again, we don't know which one of those tests is what led him to form an opinion one way or the other about whether this defendant was in fact suffering from any type of sexual deviancy.
Does any of that matter for our consideration? Wasn't the objections purely relevancy? I mean, Daubert type of and qualification issues weren't a part of the objection, were they?
I think the state's objection, the state objected before he took the stand, that he should not be allowed to testify about this sexual deviancy. And then, yes, we did argue that it wouldn't be relevant. And then the defense, when asked their position, basically just said, well, we think it is relevant. So I would submit that to the extent that it wasn't part of the record below, that the defendant, as the one who's trying to proffer why the evidence should come in, that to the extent the record is not developed, that is something that would fall on the defense here, because they were the ones that were who were the proponents of the evidence that they're now seeking to get in.
Counselor, if we disagree and find that evidence that he did not suffer from sexual deviancy sufficiently proffered, why doesn't that show a character's tending to prove guilt or innocence of the offense charged?
Well, and that's where I struggle. I certainly didn't find any case law directly on point with respect to a defendant trying to get in this exact type of evidence. I think the closest that I found and that I cited was in, I believe in Prine, where a defendant was not allowed to present evidence that on prior occasions he had behaved appropriately around young children. And my argument is that if you're not even allowed to bring in specific instances of conduct to show, basically trying to show that you weren't guilty because I've behaved on other specific prior occasions, then I would think that it would be even less appropriate to just be able to put on opinion testimony based on a test that a medical expert has performed.
I think that's maybe where you're at a disadvantage based maybe on the proffer, because the statute 445 through 447 specifically excludes specific instances as a method of proving that character or trait, but it does authorize expert opinion or opinion testimony. It doesn't specify lay versus expert, but I guess that maybe bolsters your point that without a proffer that gave the district court and the parties an ability to frame it under that analysis, our hands are tied.
Correct. Much the same as maybe an analogy that comes to mind is, let's say there's a question about hearsay and the state is trying to get in evidence under one particular exception to the hearsay rule, and that's all that's litigated below. And then the issue comes up on appeal and the argument is, well, actually, it should have come in under a different exception. Well, again, the district court wasn't in position to evaluate that, and clearly the parties below wouldn't have been in position to argue that. So, and I do, to Justice Standard's questions, I had the same thought as I worked on this brief, thinking, clearly, I don't think there's any possibility that the state would be able to put in evidence. Let's say that, to use your example, which I think I might have pointed out in the brief, if the testing had shown that he was suffering from a sexual deviancy, but if there was no indication that he had ever actually acted out that deviancy by committing any type of a sexual crime, then I don't think that there's any scenario where the state would be able to come in and say, well, we want to put this in, even though he's never committed a sex crime, the testing showed that he might have this deviancy, and so we think it's therefore relevant. I know that now counsel has argued, I think citing to 447, that there's a difference between what the state can do and what the defense can. And again, if I had been given the opportunity to brief that, I think I'd have a more coherent answer for you. But I think my bottom line position on this is that in light of the record here and the very limited proffer that was actually made at the time that the defense was trying to get this witness to testify, that's what I would argue the court needs to look at, not something that happened after the trial was over, long after the jury had been discharged, and there was really no way to reevaluate this issue. And also, as I indicated, I don't think that this court can speculate about what's in an exhibit that even if the district court might have looked at it, this court cannot see it to determine whether the district court erred. Alternatively, as a final argument, I would just fall back on harmless error analysis. Again, circling back to issue 1, there were numerous injuries in this case. The medical evidence did indicate that many of them could have been consistent with non-consensual, and that some of them, in fact, were not consistent with medical efforts to resuscitate. Again, we have the victim's health history. We have the knowledge that her friends and neighbors have of her. And then we just have, quite frankly, the incredible explanation that the defendant gave for this entire episode. So in light of that, I don't think that a jury, and as Your Honor pointed out, as the Chief Justice pointed out, and as I think I did in the brief, clearly not all sex offenses are committed by people that have diagnosed sexual deviancies. I know it's outside the record here, but I think it's so well known in society at large. You've heard it from time dating back to even when I was a kid. I remember constantly hearing that oftentimes, if not most times, rape, crimes of sexual violence are often not about sex. They're about power. So the fact that he has a doctor who might be able to come in and say that these tests didn't indicate a sexual deviancy, I clearly don't think that there's any possibility that that is going to would have affected the verdict when you have this overwhelming evidence that the state presented that this was in fact not a consensual act, that this was a man who was preying on an a woman who was suffering from a lot of health challenges and had limited mobility and didn't even want this man to be on her property anymore. If there are no additional questions, we would respectfully request that the defendant's conviction be affirmed.
Thank
Thank
you,
you.
Mr. Maloney. Stratton, you reserve 3 minutes.
Just two things. The first is that it is true that we did not cite 447 in our brief, however, the state did. So it seems as if it was fairly at issue. The other thing, the more important thing is that the state was discussing ambiguous medical evidence, how we characterize it as ambiguous medical evidence, and we do. And that's part of what we believe the state's story was. We believe the state's case had two parts. One was this, what we called in the brief, ambiguous medical evidence, which is what I'm calling non-probative because it's so ambiguous, it doesn't tell us one way or the other. It just doesn't speak on the issue of consent. The other part of the state's case is this story. And it's proper to draw inferences from the facts. A case can rest on circumstantial evidence for sure. But what a case cannot rest on is inferences that are unsupported and that rely on sort of implicit biases, not just in the jury, not just in me, in our culture. And that is that women who are older and people with disabilities are not interested in sexual expression. This was really the state's case, because again, the medical evidence didn't tell us one way or another about consent. And there was, a little bit of evidence that she was celibate. Why is an open question, but mostly, and I can read the state's own words in opening and closing. And as my colleague stated, this is about her age. She was 72 years old. The state said that 4 times in opening and 4 times in closing, and her disabilities, which again, the state just recites, she had lung disease and heart disease, and she sometimes walked with a cane, and therefore she must not have consented because everybody knows that older women and people with disabilities just wouldn't consent. So it's those impermissible inferences, it's inferences that are unsupported by the evidence that we think really carried the day with the jury, and that they are part of how the state failed to present sufficient evidence.
Counsel, if I could turn again to the sexual deviancy testimony. When at trial, when they were discussing whether or not it would be admitted, Mr. Owens, the defense attorney, said, "Yes, Your Honor, I understand the state's position. The only thing I would add on our side of the situation is I think it is relevant. We aren't talking about any type of specific behavior or if Mr. Pepper has more proclivity to try to rape somebody or not try to rape somebody." So the basic fact is that Dr. Parker found that Mr. Pepper does not suffer from any type of sexual deviancy, even though he's charged with aggravated criminal sodomy. And it isn't overwhelming. There's no allegations. It's not particularly at issue whether you know those particular points. The particular point is we have a sexual act, and that's our position, Your Honor. So in saying that there's no specific type of behavior, I have a question as to what sexual deviancy even means in that context or how we can judge it. And also, when he said the statement that Mr. Pepper has, we aren't talking about any type of specific behavior, or if Mr. Pepper has more proclivity to try to rape somebody or not try to rape somebody. So if it doesn't demonstrate more or less proclivity to rape or not rape, how does that go to guilt or innocence? So those two things.
Yes, I remember exactly the sentence you're talking about, and I think it was poorly stated, specifically the second clause. So the first clause where he says, "We're not trying to point out specific instances," is because the defense was disallowed from doing that. So that I think is correct. The second sort of phrase in that sentence, I think is confusing. I agree. But I don't think it negates the proffer he gave earlier in that paragraph where he said, "The fact is, Judge, that he's charged with this sexually deviant crime, and our expert who has a validated scientific way of testing for this sort of thing can show that he does not suffer from sexual deviancy. That is the best proffer we have. But again, it's not the only proffer we have. So in day one, this was brought up, that there is I wish I had it with me, but counsel and the court talked about this issue, and the court sort of said, well, we'll talk about it later when it's defense's turn and they're trying to bring Dr. Parker to the stand. So, and again, we had a 15-page report, we had motions practice, we had a pretrial hearing. I mean, that one, I think 2-paragraph statement in day 4 of the trial is not the first time this came up. It's not the first time the court heard of this. That's sort of a recap of the proffer.
So you want us to consider as part of the proffer what was said pre-trial and what was said before sentencing and a motion for durational departure or motion for departure.
I think that Swint, which is the case given by the state, allows that, yes. And the wording that allows that is actually in the appellee's brief. Thank you very much.
Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement